All right, welcome back to our media copyright and licensing class. This is part two of our look at infringement. And you will recall that this week you've got your fourth assignment um, and the last assignment before our test next week. And there'll be more information coming on that as well as a study guide. But these assignments and the worksheets I've been giving out to you will be a primary resource for your preparation for the tests. So this will be the first of 4 tests in the class. And they are at the end of all of our different sections. So we're going to wrap up copyright pretty soon here. But for this week's assignment, as usual, you'll want to go to the section on okay, this is the wrong class, so give me 1 second. There we go. All of the information for your assignments can be found on infringement. Assignment 4 can be found here on the class Canvas page. So on the fourth assignment, you can see the directions as usual. I've got 5 steps that you have to do. They usually end up being about 1 point each. But you do get to choose, what kind of area you're interested in. And so a good way to find out about, copyright and licensing, of course, is to see how the law performs in a court of law, during a court case. And there are court cases that are referred to in your textbook. And so chapter 1 covers 2 famous court cases on infringement. Chapter 2 has case studies dealing with performing rights. Chapter 3 on mechanical rights. So there are, I'm referring you to areas within your textbook. And when you locate your case studies or the court case, so a case study doesn't have to be a court case itself, but it can be. But there are court cases and case studies available in the textbook. So I'm referring you to, to these 1, 2, 3, 4, 5, 6, 7, 8 different topics. You can get into downloading, sampling, songwriter deals, synchronization, etc. So you pick what you're interested in, and then you use the textbook to introduce the topic, and then you'll want to search and take notes on 2 additional online resources. And then, write a short synopsis of the case in 1 paragraph, so about 5 to 7 sentences, what actually is the case study about or the court case. And then in a second paragraph, why is this, what is the takeaway, right? So what's the relevance to today's industry or to your place in the industry? What do you personally take away from it? All of that is fair game. So you just have to make it relevant in the second paragraph. You'll want to link the websites that you visited so I can see your work there. And then submit either, that should be either, not whether, by either copy and pasting the assignment or uploading it as an MS Word /docx document. Okay, so that is our assignment for this week, and keep an eye out for next week being our test. Okay, and there will be, as I mentioned, resources coming along for the test in the way of a study guide and a sign-up sheet for when you want to take it, and there'll be more information about how that will all work. Okay, so in the last presentation we talked about different types of infringement, different types of infringers, and kind of how the court cases are set up in terms of actually proving infringement. And in this one, I want to talk a little bit about the defenses and the remedies. So remedy is, if you're found in violation of a law, the court will assess a penalty or propose some way that the law be observed. And so if you pay or do jail time or whatever it is, that's what I'm referring to as a remedy for the infraction, right? The broken law. So it's penalty or remedy, basically the same thing. Okay, so the topics for today: history of anti-infringement legislation. It's good to see, as we have located the relationship between technology and the law as being, uh, technology sort of driving various issues that the law or government basically has a chance to sit back and observe and see if it's making waves, if it's in need of regulation, and then the law will follow behind technology and regulate as needed. And so you can see the issues sort of through the lens of legislation. So if you recognize that relationship of one is faster than the other, then you look at the laws themselves, and you can kind of see different kinds of technology kind of popping up and how the law reacts to those situations. Then we'll talk about some technicalities, one of which was, we mentioned in the last presentation. So if you get off on a technicality, that means that the court case can be thrown out for various reasons, like the statute of limitations has expired. So if you try to file an infringement case and the only proof of infringement you have happened more than 3 years ago, then that case will be dismissed on a technicality, being that one being the statute of limitations. Then we'll review the proofs that we saw last time. How do you actually prove a case of infringement in a court of law? And then what are the defenses? And we'll go from weak defense to strong defense. We'll look at abandonment, independent creation, de minimis, fair use being some of the most controversial ones in particular. And then penalties. Now, copyright's typically a civil case, but there is such a thing as a criminal copyright, and so that's two different courts, right? Types of trial: criminal case versus a civil case. O.J. Simpson's trial is probably the most useful example of when the public became aware of that distinction, because he was acquitted in the criminal case and did not go to jail for the murder, of Nicole Brown Kidman and her, alleged lover, but he was found guilty in the civil case and stripped of, a lot of his worldly goods, large fines, lost his house, etc., etc., etc. Okay. So in terms of, we're going to start in the recent past and just look back at some of the laws that have, been dealing with infringement. So the Artists' Rights Theft and Prevention Act of 2005 was really the first time that you see the issue of illegal downloading getting some teeth in it, right? So there were laws passed before ARTPA, but they didn't amount to much. They didn't allow for courts to impose much in the way of penalties. And so now you've got a maximum 10-year fine for illegal downloading. And then, of course, this is 5 years after the whole thing, 5 or 6 years after the Napster, story broke, and that whole issue of, P2P file sharing, i.e. piracy. In 2005, that same year, we've got the strategy for targeting organized piracy, when the Recording Industry Association, so basically the CEO of all the major labels, joins up with the U.S. Chamber of Commerce in order to identify and isolate infringing websites. So sort of getting them out of the mainstream of internet accessibility, I guess you could say. And then in 2006, the Stop Counterfeiting Manufactured Goods Act, not only did you have, the impersonator Gucci sweatsuit on the list of, what was being targeted there, so designer brands, but you had, counterfeited audio, and recording goods as well. So now you've got a secondary increase to what's referred to as the power of injunction. And so when a court orders that someone cease and desist in the, if they're doing an infringing activity, the court will write a cease and desist letter and file an injunction, which means that they need to stop the distribution. And so they're kind of shutting down the operation through injunction or through assessing damages, or by confiscating the infringing material itself. So if you're using different sort of equipment to conduct this infringing activity, illegal duplication of, in this case, designer clothing, all the way down to audio recordings, etc., then the court has the power to confiscate either the illegal goods themselves or the machinery / materials that were used in a contributory fashion, as we learned last time, to support the enterprise there. Now, when you look a little bit back further in time, you can see, as of the 1960s, it was illegal to copy labels, but that was a common law or a state law legislation. It wasn't until 74 that Circle P actually came about as a federal protected category for audio recordings. And so pre-74 recordings were in a bit of a loophole situation where an infringer could get busted in one state and get fined and then just go across state lines and resume operations as if nothing had happened. And so the federal penalty enabled a more sort of consistent and widespread application of the law for the entire country. Then in 1982, Circle C and Circle P infringement were bumped up to felony level, which was an important way in terms of deterring people, because people with felony convictions, that tends to follow people around and prohibits them or makes it more difficult to get certain kinds of jobs. 1989 and 94, you've got the integration of the United States into the Bern Convention. And so Bern is a city in Switzerland where this, meeting was held. But basically, it was a reciprocal agreement saying that the United States would prosecute infringers that were they had this agreement with, if somebody's from Canada or from Spain and they're in the United States. Spain and the United States are both participants to the Bern Agreement, meaning that and the agreement states that the United States can prosecute Spanish citizens who are infringing on U.S. soil according to U.S. law, and the United States in turn says that if Spain apprehends United States citizens that are infringing, that they can they are free to, they don't have to be extradited, right, sent back home. They can be tried in Spain according to Spanish law as a result of this agreement. So it's a bilateral or a multilateral accord. In 1994, the penalties were increased for Bern members, especially on the side of Circle P. And then 1997, the No Electronic Theft Act, or the NET Act, criminalized illegal distribution. So those are a few different laws that let you sort of trace the development of infringement as an issue that is addressed by the United States government in various ways over different eras. Infringement proof. So we talked about direct proof versus circumstantial proof. Do you remember which is more common? Is it more common to have a smoking gun or to have to tell and reconstruct the story of what happened? Okay. Use the comment section to take your shot at that. We talked about that in the last presentation, but which one do you think it is more common, direct or circumstantial, and why? And then, as the case is built, there are what's known as technicalities. So when you bring an infringement case, we talked about the statute of limitation. It can be thrown out if it's beyond 3 years past the last known infringement. But there's also something called abandonment. And so if you have, if your copyright notice, so where it says, Circle C 1989, Paul Linden or whatever. If that notice is listed improperly, it used to be more regulated, but that was something that shifted with Byrne. You can see 1989. So pre-88, if that copyright was listed improperly, then the copyright could be considered, it could go right into the public domain. So it was an abandoned copyright. If you say this is part of the Creative Commons, or you're free to copy, or you didn't renew, etc., all of those copyrights are considered to be abandoned and therefore public domain. So those would be considered technicalities. And then, of course, you'll remember about federal registration would be, affording prima facie evidence. And so it's the presumption that anybody who shows you the copyright certificate, from the United States, that federal registration is presumed to be the owner, and the burden of proof shifts to the other party. Okay, so there's some technicalities that go along with that as well. Okay, defense, check that out. Football fan. So if a defendant has to defend themselves from the charge of having infringed, and defenses and copyright vary, right? So strong is on top with bold print, and weak is on bottom with regular not bold print. And so the statute of limitations is probably the strongest, because if you're outside of the statute of limitations, even though it's a technicality, game over, right? There is no case whatsoever. Same with abandonment. Independent creation is a claim, and so that has to be built up circumstantially. Fair use also has to be proven. And de minimis and innocent intent are really to the point where, de minimis is like saying, using the old, 3-bar rule, where I didn't borrow more than 3 bars from this song, and so then therefore I'm innocent of infringement. So that actually doesn't exist. You can borrow so little that it's considered to be inconsequential, but where that is relative to a certain amount of music does not exist. And so those are your innocent intent, I didn't mean to, are going to be, those are the weakest arguments that you have in terms of defense of copyright infringement. So when you claim independent creation, basically the idea is saying that I don't need to steal somebody else's song or artwork, because I have a record of independent creation, so I'm already a creator. I don't have to steal because I'm already good at what I do as a creator. And so if you have documents that support your creation, like a lyric sheet or a chord sheet or digital audio workstation files, all of those point to and verify your claim that you don't need to steal because you are you've got a record of independent creation. There's Urkel. Oh, did I do that? So de minimis, it reminds me of Urkel, right? It's, did I do that little old thing? I can't believe it. Was that bad? Should I not have done that? Right? So innocent intent, I thought it was public domain. Whoops. That's a claim. That's a weak claim. But it is still a claim that, and sometimes it can hold up. Not that, that's innocent intent was, did I do that? De minimis is, you see the word minimal is shares, that's a Latin term. So minimal comes from minimus, meaning of a very small amount. So de minimis means that such a small amount was used that it really shouldn't be considered as, it's not a big deal, it's not like I use the entire hook or an entire verse. I just used a little bit. And so not a strong defense, but it's defense all the same. Now, as you move up the line to a stronger defense, there's this whole category of fair use. And this is a gray area where you find a lot of, debate, a lot of court cases on fair use. People who think that just because they use something in an educational setting, it's therefore fair use. That can be a problematic assumption, right? So fair use is a gray area that when you claim fair use, now you've got to to prove that it in fact was fair use. And so you've got these subsequent tests like the is it for profit or not for profit, right? So if your use is for an endeavor that is not profit seeking, like research or journalism, for example, or worship, although that's debatable to a certain extent, then that would be on the side of more fair than not fair. In the second case, what is the nature of the work of art, of what was borrowed? Is it more factual or more creative? The factual being more towards fair use, creative being less towards fair use. How much did you borrow? Was it substantial? So under the second point here, right over here, these are all questions. What was the effect of the new work on the value of the original? If it brought the value of the original down because people got what they wanted to through this new use, that would be considered not an unfair situation for the original copyright holder, and so it's not a fair use situation. So I made this little chart here to kind of sum all of that up. Less likely to be fair use if it's very creative, if you're borrowing the whole work, if it makes a significant impact on the original work, if it's commercial in value, as opposed to the opposite over here. So red is danger, black is more safety. And so basically fair use allows you to say, I'm going to use some work that doesn't belong to me without the owner's consent, and I won't be an infringer. And so some of the examples of, less commercial, less creative, more factual uses that would be deemed, quote, fair would be using something in an educational, face-to-face setting, churches, for worship, journalism, scholarship. And then this last area, parody versus satire, is probably where you've got most of the contention about what is or is not fair use. So the distinction between parody and satire, anybody who knows Weird Al, right? He's a famous parodist. And so the difference between parody and satire, so satire is using a work of art to make a larger critique, of cultural customs or of cultural behavior, of norms. Whereas, and so that's not fair to borrow somebody's work in order to do that, right? But you can, the law says, borrow somebody's work to make fun of itself. And that's kind of an interesting thing, right? So when Weird Al took Michael Jackson's Beat It song and changed it into a guy who ate too much and recorded Eat It, right? He's using the exact beat, a lot of the same video structures, or shot types, but he's just changed the content, removed the letter B, and now it's about somebody eating too much. So he's just using art to poke fun at itself. And so the law says that you're actually protected. That is fair use to do that. And so in order for a work to be fair use on the grounds of parody, it really needs to resemble the original quite a bit, but not be it, right? So I think the Weird Al example of, changing Beat It to Eat It is about as clear of an example as I can find, but there are a lot of cases that really get down to the nitty gritty and get into this. Two Live Crew has one, taking Roy Orbison's Pretty Woman case. That's a famous one if anybody wants to work with that one for their case study. Okay, so let's talk a little bit about penalties. So we know how the court cases are filed, where they're brought, how much it costs, who has the right to do it, how you actually make the case, how the defendants defend themselves. Now, at the end of the day, the judge is going to say, I'm going to throw it out or I'm going to find you guilty. And so what happens in a guilty verdict is any one or combination of, in a civil court, which most of, these trials will be, to have criminal copyright is, a much larger, right, fraud. And it's usually has to be repeated on a larger scale and somebody's already been warned. And it's like, okay, you're getting into criminal intent here. Civil is usually doesn't involve, possibility of incarceration, for example. But what you can have, as I mentioned, is injunction, which is that cease and desist, stop the distribution. You can have impoundment, so you're confiscating the materials that are being sold or the equipment that's used to do the duplication. That equipment can then be destroyed, so you've got a destruction of infringing materials, confiscation of the profits themselves, and the assessment of additional damages, which can be assessed on a sort of legal equation, so that would be statutory damages, or you could do the math and say this is how much I actually lost, and then the judge could say, okay, we're going to fine for actual damages in that situation. So those are the penalties that are most commonly associated to a civil copyright case if the defendant is found guilty. And once again, joint and several liability do apply here. And so you'll remember that we've got multiple types of infringers. The one that actually did the duplication being the direct infringer, all the way through contributory and vicarious. And those are all in the line of fire potentially. It's up to the judge. So they can all be found, and all be found liable, right, for infringement and have to pay or have their materials confiscated or whatever it is, or one of them, or two of the three, or whatever it is. So it really depends on the plaintiff's ability to sort of seek remedy, right? For this for justice to be found, right? So they need to collect the fees to repair the damage of the actual, problem, the actual, what is it? The infringement itself. Criminal penalties. So here we've got, a repeat offender on a larger scale, working, for personal exploitation, extreme willful damage to the plaintiff. It's got to be pretty outrageous for infringement to rise to the level of criminal activity, but that is on the table. It's possible. And so here we're looking at, $250,000 for an individual and 5 years of imprisonment, or if it's for a corporation, $500,000 fine there. And so that is going to basically wrap it up for us looking at this issue of infringement this week. Please post any questions that you might have. Do look at at your textbook for case studies. I'm letting you kind of have free reign. The idea here is with this assignment that you choose a topic that you're interested in. The book is going to give you a sort of springboard, right? A little bit of information about a couple cases. You can look into that with deeper research. So you need 2 extra sources. And if you like what you find, if you like the process of doing that, then this would be something that you should consider for your final presentation. So I'm trying to get you guys interested in an area of copyright and licensing so that when the final project comes around, it's more something that you want to know about and you want to do than something that I'm like, you have to have A, B, C, D, which you will anyways, but the idea is that you'll enjoy doing it. So be thinking about that as you do these. Take your time and find something that is genuinely interesting to you, and I guarantee you it will pay off later. All right, folks, let me know what you think. Have a good day and week.